The Supreme Court heard arguments on Wednesday in the Mississippi case challenging Roe v. Wade. This comes just a month after the High Court took up Senate Bill 8, the Texas Heartbeat Act. So what's the difference between these two anti-abortion bills? Let's break it down. The Mississippi case is Dobbs v. Jackson Women's Health Organization, and it's challenging a law that bans most abortions after 15 weeks. According to the CDC, more than 95% of abortions happened at or before that point in 2019. The law, which was passed in 2018, does include exceptions for medical emergencies or severe fetal abnormality, but not incest or rape. And this law is enforced by the state, which is why the case is drawing comparisons to Roe v. Wade. In that 1973 decision, justices ruled states can't ban abortions before fetal viability, which most experts consider to be around 23 to 24 weeks. Now let's look at Senate Bill 8. It actually faces two challenges in the Supreme Court. The Department of Justice is suing Texas over the law, but justices really seem to center on Whole Woman's Health v. Jackson when they heard arguments on November 1st. SB8 bans abortions around 6 weeks or when a heartbeat is detected. I'll explain why that's in quotations in a sec. That same CDC report I mentioned earlier says roughly 43% of abortions happen at or before 6 weeks. Texas lawmakers just passed SB8 in 2021, and similar to the Mississippi law, it does not make exceptions for rape or incest, only medical emergencies. The most significant difference between these two is enforcement. SB8 allows private citizens to sue anyone who aids or abets a woman getting an abortion once a heartbeat is detected. And I'm circling back to this because it's another point of contention. Experts say using the word heartbeat is misleading since the activity detected is electrical impulses, not a true heartbeat, as the embryo's heart isn't fully developed. But the big question mark here is the constitutionality of that enforcement mechanism. The Mississippi law has been blocked by lower courts, so it is not in effect. SB8 very much is, after the Supreme Court declined to step in sooner. Now the future of both is in the hands of these 9 justices.